This podcast covers criminal procedure. The Fourth Amendment of the United States Constitution provides that people should be free from unreasonable searches and seizures. What constitutes a search? A search is when the government looks for evidence in an area that a person has a reasonable expectation of privacy. Thus, if you are walking to your car after class, you would not expect the police to approach you and start rummaging through your backpack for no reason at all. You have a certain expectation of privacy in the contents of your backpack. Same thing if you are driving home from class. You do not expect the police to pull you over and search your car for no reason at all. Again, you have an expectation of privacy here. Now, what about this scenario? You take your trash out to the curb for pickup the next day. The police rummage through the trash that night. Can you claim this is an unreasonable search? Well, that would be difficult. That would be a difficult claim to make because there is a low to really no expectation of privacy at all in the trash that you are expecting to permanently dispose of. What constitutes a search? Or what constitutes a seizure? A seizure is when the government takes control of one's property or person. The general rule is that if the government wants to search a place or seize evidence from a place that a person has a reasonable expectation of privacy, the government needs to obtain a search warrant. The question you want to ask is, does the person have a reasonable expectation of privacy in the item or place being searched? One example is Officer Observant is walking into a residential neighborhood. He notices Derek in his front yard cleaning an illegal assault rifle. Officer Observant seizes the rifle and arrests Derek. The rifle may be admitted as evidence against Derek because there is no expectation of privacy in an unfenced front yard bordering a public walkway. Example 2, Officer Nosey walks past Joe's garage and decides for no particular reason to pull at the corner of a piece of cardboard covering a broken window. The other windows of the garage are all painted black. When he moves the cardboard, he sees what he knows to be a stolen guitar in the corner. Because Joe has taken the necessary steps to protect the interior of his garage from public scrutiny, he has a reasonable expectation of privacy in the garage, and Officer Nosey's actions constitute a search. Officer Nosey's actions are unconstitutional. He must obtain a warrant. Just about all legal rules have exceptions, and the general rule requiring a warrant for a search and seizure are no different. Let's turn to exceptions to the warrant requirement. There are several. The first exception to the warrant requirement is consent searches. The defendant consents to the search. The police are not required to inform the defendant of the right to refuse consent. For example, after the police stopped defendant for speeding, gave him a verbal warning, and returned his license, the police asked defendant if he was carrying any drugs in the car. Defendant answered no and consented to a search of his car, which uncovered drugs. Defendant argued his consent was invalid because he hadn't been told he was free to go after his license was returned. The Supreme Court found no such warning was necessary. The second exception to the warrant requirement is evidence in plain view. In order for this to be valid, this must occur from a lawful vantage point. The police must have probable cause to believe the item is evidence. For example, the police may seize from a lawfully stopped automobile an opaque balloon that the police have probable cause to believe contain narcotics. The third exception to the warrant requirement is emergency searches. This exception is to check the welfare. The police must believe a person is in need of immediate aid. For example, there is a fire in a home. One example occurred where a neighbor called 911 and reported hearing yelling and screaming and the use of a code word by the woman in the house, set up with a neighbor, which meant that something was seriously wrong and that the neighbor should immediately call the police. The police in that case did not need a warrant to enter the home. In another example, the police overhear a loud argument in a hotel room, but there are no sounds of a physical struggle or any other indications that an act of violence has occurred. Here, the police would not be justified in entering the room to make sure everyone is okay. Another exception to the warrant requirement occurs when the police come across evidence that is likely to disappear before a warrant can be obtained. For example, a blood sample containing alcohol or fingernail scrapings. Such evidence is called evanescent evidence. An exception is also made for an inventory search of an automobile. If the police have probable cause to believe that a vehicle contains evidence of a crime, they may search the vehicle without a warrant. The rationale is that people have less expectation of privacy in their vehicles than in their homes. The police do not need a warrant to conduct a search incident to a lawful arrest. The police may search the person and areas into which he might reach to obtain weapons or destroy evidence. If an arrest is unlawful, then any search incident to the arrest is also unlawful. For example, if the police arrest defendant Dan for murder based on a hunch and without a warrant or probable cause, then the arrest is illegal and any evidence they find when searching Dan after his arrest is illegal. Police officers in hot pursuit of a suspected felon may make warrantless search and seizure. This is another exception to the warrant requirement. The police may pursue the felon into a private dwelling if the police has probable cause. So if defendant Don robs a bank and runs to his home with the police on his heels, the police don't need a search warrant to break down his door. Anything held out to public inspection, such as odors emanating from luggage, inherently lack an expectation of privacy, and so no warrant is required. Let's say Dudley is attempting to transport marijuana across the country. In the bottom of his suitcase, he places several pounds of marijuana and places private do not smell stickers all over it before checking it in. Nonetheless, the police, without a warrant, present his bag to a drug-sniffing dog along with the other bags on his flight. The dog alerts the officers of the presence of the drugs, and Dudley is removed from the plane prior to takeoff. Despite Dudley's stickers, he did not have a reasonable expectation of privacy regarding the odors, and the warrantless search by sniffing was legal. The exclusionary rule is a judge-made doctrine. It prohibits the use of evidence that was obtained through unlawful search or seizure in violation of the defendant's Fourth, Fifth, and Sixth Amendment rights. Such evidence is inadmissible at trial. The fruit of the poisonous tree means that any evidence stemming from the unlawful search or seizure will also be excluded. This is also a judge-made doctrine. Let's say the defendant is arrested without probable cause and brought to the police station. The police officer reads defendant his Miranda warnings. After being at the station for several hours, defendant confesses. Is the confession admissible? No, it is the direct result of the unlawful arrest. If the defendant had not been arrested illegally, he would not have confessed. Now let's say the defendant is arrested without a warrant and then released. Later, the defendant returns to the station to confess. Is this confession allowed? Yes. The defendant here returned on his own free will to confess. Here, it was not the result of the illegal arrest. Just like we have been discussing, most legal rules have exceptions. This one is no different. There are 3 exceptions to the exclusionary rule. 1, if the police had an independent source for the evidence aside from the fruits of the illegal search, then the doctrine will not exclude the discovered evidence. For example, Officer Brady illegally searches Donald's barn and discovers documents identifying Donald as the culprit behind an internet scam. The next day, a confidential informant emails Officer Brady the same documents. The documents are admissible as evidence because there was an independent source for the evidence besides the illegal search. The second exception to the exclusionary rule is inevitable discovery. The evidence would have been discovered through lawful means. For example, the police conduct an illegal search of defendant's home and find a map showing the location of an outdoor marijuana field located 50 feet behind a busy commercial strip. The police go to the field and seize the marijuana. The marijuana may be admitted as evidence by a court. Although the police were led to the field by information discovered during an illegal search, a court could find that the discovery was inevitable, given the field's proximity to the commercial strip and the fact that the field was not well hidden. In another example, the police perform an illegal search of Fred's residence and discover stolen goods. On the counter, they find a notepad on which Fred wrote the following: "Reminder, place newspaper ad. Computer stuff for sale, cheap and hot. Call Fred 555-1234. Based on this, the police call the number and that leads them to more evidence against Fred. The discovery here was not inevitable because the ad never ran. The evidence here will be excluded. The third exception to the exclusionary rule is good faith. If the officer believes that a warrant is not required for a search or conducts a search pursuant to a defective warrant which he believes to be valid, the officer can be said to be acting in good faith. On the other hand, if he knows or should have known of some defect in the warrant, the good faith exception will not apply. For example, Officer Careful executes a search warrant in accordance Officer Careful executes a search in accordance with a search warrant obtained from Judge Hatchett. Unknown to Officer Careful, Judge Hatchett issued the warrant after an incorrect finding of probable cause. Although the search was illegal, the evidence here is not tainted and does not fall under the exclusionary rule, because Officer Careful here was acting in good faith upon the judge's finding. If otherwise relevant and admissible here, the evidence may be considered. In another example, Judge Doe issues a warrant based on Officer Ellie's sworn testimony that he saw El Bronco removing stolen shoes from his trunk and carrying them into his home in Big Town, California. The warrant is made out for that property owned by Mr. Al Bronco in Big Town, California. Well, unbeknownst to Judge Doe, Al owns several houses in Big Town, one in which his mother lives and the others which he rents out. Officer Ellie is aware of this and executes the search on the intended home. Because the warrant is not precise, in this case it's not precise, Officer Ellie's search cannot be said to be conducted in good faith, and the exception to the exclusionary rule will not apply. So any evidence discovered from the search or stemming there from the search will be excluded. We are now going to turn to the topic of arrests. A warrantless arrest for a crime committed in public place requires probable cause. Probable cause is reasonable grounds to believe a crime was committed and the suspect is the person who committed the crime. It is more than a mere suspicion. It is also less than beyond a reasonable doubt. The officer must look at the totality of the circumstances. An arrest warrant is required to enter a suspect's residence unless the police are in hot pursuit of a suspect. With regard to an investigatory detention, also known as a stop and frisk, the police may briefly detain a person or an automobile for investigative purposes, even if they lack probable cause to arrest. To make such a stop, the police must have a reasonable suspicion of criminal activity. If the police also have reasonable suspicion to believe the detainee is armed and dangerous, they may conduct a frisk, which is a limited search or pat-down of the outer clothing to ensure the detainee has no weapons. If during this investigatory detention, the officer develops probable cause, the detention becomes an arrest. The police can then conduct a full search. Stop and frisk is a controversial program, as we have seen over the years in the news. The practice is not unconstitutional, but a judge did rule in 2013 that New York City's stop and frisk program was carried out in a manner that violated the U.S. Constitution. The judge found that the city police violated the Constitution in the way that it carried out its stop and frisk program, calling it a form of racial profiling of young Black and Hispanic men. But the judge did not rule that the practice itself was unconstitutional. The Fifth Amendment to the United States Constitution states that no person shall be compelled to be a witness against himself. This has been interpreted to mean that a person shall not be compelled to give self-incriminating testimony. A person in custody must, prior to interrogation, be clearly informed that He has the right to remain silent. Anything he says can be used against him in court. He has the right to the presence of an attorney, and if he cannot afford an attorney, one will be appointed for him if he so desires. These warnings are known as Miranda warnings. The name comes from the 1966 U.S. Supreme Court case, Miranda v. Arizona. When are Miranda warnings required? Anyone in police custody must be given warnings prior to interrogation by the police. How do you know if a person is in custody? It depends on whether the person's freedom of action is denied in a significant way. For example, defendant is awakened in his own room in the middle of the night by 4 officers surrounding his bed, who then begin to question him. Is the defendant in custody? Yes. Defendant would not feel free to walk away in that scenario. Are traffic stops considered custody? Do Miranda warnings need to be given? No. Traffic stops are brief. What does interrogation mean? Interrogation is words or actions on part of the police that the police should know are reasonably likely to elicit an incriminating response. So, for example, what if an officer makes comments to a defendant about how dangerous it is to have a hidden gun? The police tell the defendant that children could find this gun and it could accidentally go off, etc. These comments result in the defendant showing the police officer where the gun is hidden. Are the police comments interrogation? No, not if the officer did not think it would lead to an incriminating response. A suspect can waive his Miranda rights. In order for the waiver to be valid, the waiver must be knowing, voluntary, and intelligent. Any sort of a threat, promise, physical force, or mental coercion on the part of the police, which leads to a waiver of the defendant's Miranda rights, will result in the confession being thrown out or the evidence being suppressed. With that said, the defendant's waiver of her Miranda rights can be either express or implied. One example of an implied waiver of Miranda rights is this scenario. After being informed of her right to silence and to an attorney, also known as Mirandized, a suspect proceeds to make self-incriminating statements during interrogation. She may be found to have waived her right to silence by having been notified of her Miranda rights, understanding those rights, and then proceeding to make self-incriminating statements without an attorney present. Her waiver is implied but is valid. Another example is the following. Beth is arrested for the stabbing death of her abusive husband. After being properly read her rights, or Mirandized, Officer Gentle asks what kind of relationship she had with the deceased. Beth replies, "Well, all I can say about it is that he was a no-good, drunken slob, and I'm glad he's dead." Officer Gentle then says, "I'm glad too, and I'd sure like you to tell me which knife you used to kill him." Beth then asserts her privilege against self-incrimination by refusing to answer any further questions. Is Beth's response to the initial question admissible? Yes, she impliedly waived her rights when she answered Officer Gentle's question. The waiver is valid. Can Beth be compelled to respond to any further questions? No. She has the right to remain silent. If the suspect wants an attorney, the suspect must specifically request it. Let's say the police officer gives the suspect Miranda warnings and the suspect confesses. Meanwhile, the suspect's lawyer is outside and attempting to see the suspect, but the police officer never tells him this. Is the confession admissible? Yes, the waiver was voluntary, knowingly, and intelligent. The officer does not have to tell the suspect about the lawyer. If a suspect requests an attorney during interrogation, all questioning must cease until the suspect gets an attorney. If an officer continues to question the suspect after the request is made, any statements made are thrown out. We will now briefly discuss the procedure from arrest through trial. First, the suspect has her initial appearance before the judge. The initial appearance takes place within 24 hours of the suspect being in custody. The suspect is informed of his rights, such as the right to counsel. He is informed of the charges against him. Counsel is appointed if necessary. Release conditions are established, for example, bail is set. This is granted by statutes or court rules. The preliminary hearing takes place next. This is where the judge determines if probable cause exists that 1, a crime has been committed, and 2, defendant is the one who committed it. During this hearing, the rules of evidence are relaxed. The accused has the right to counsel at this hearing. The defendant can straight waive or bypass the preliminary hearing if the state agrees. The state may want to put on a preliminary hearing. This might occur, for example, in a domestic violence case where the state wants to lock the victim into her story before she changes her mind. The state may also want to preserve testimony of a victim who might be unavailable for trial. For example, if the victim is on his deathbed and probably won't make it to trial, the state may want to get the victim's testimony to later use at trial. A grand jury indictment is returned if a grand jury determines probable cause exists. A finding of probable cause is required, just like in a preliminary hearing. Who serves on a grand jury? Citizens. Hearsay is okay in a grand jury proceeding. Hearsay is allowed. Also, the defendant has no right to be present, no right to call witnesses, and the defendant has no right to present evidence. Proceedings are conducted in secret. What is the main difference between a grand jury and a preliminary hearing? A preliminary hearing is held in open court with the defense side present. It is an adversary proceeding. The defendant in a preliminary hearing can see and cross-examine prosecution witnesses, which gives the defense a good preview into the prosecution's case. In a grand jury proceeding, the grand jury can only see and hear what the prosecutors put before them. It is non-adversarial. Who decides which proceeding takes place, a grand jury or a preliminary hearing? It is the state that decides. The arraignment occurs next. This is where the defendant enters a plea of guilty or not guilty. Throughout the criminal discovery process, relevant information is exchanged. The parties conduct depositions and interviews. Some of that relevant information includes the prosecutor's lists of witnesses and exhibits. The prosecutor provides this list to the defendant. Defendant is allowed to interview all of the prosecutor's witnesses prior to trial. If the list is not timely provided, the witnesses are precluded or suppressed. The prosecutor must disclose exculpatory information to the defense. This is information that tends to vindicate the accused or show the accused's innocence. This is known as Brady material, named from the U.S. Supreme Court case Brady v. Maryland. The defendant must likewise provide to the prosecutor her list of witnesses and exhibits. If the list is not timely provided, the witnesses are also suppressed. The defendant must also provide her notice of defenses. What legal theories will she use to defend her case? The Sixth Amendment to the Federal Constitution guarantees the defendant the right to a speedy trial. Under the Arizona Rules of Criminal Procedure, the time limits start from arraignment and are 150 days if the defendant is in custody and 180 days if the defendant is out of custody. If the defense claims her rights to a speedy trial have been violated, these are the factors the court looks at to determine if a violation has occurred. The length of the delay, the reason for the delay, the defendant's demand for trial, prejudice to the defendant. If a court dismisses a case with prejudice, the state may not refile charges. A case that is dismissed without prejudice means the state may refile charges. And this concludes the podcast for criminal procedure.